Hi, I'm Dr. Marc Mednick. I'm a licensed psychologist and expert on family disputes. I've been doing this work for over 30 years, helping parents split up, doing what's best for their kids, working with entire families, trying to help them get through this very difficult time. A couple of things stick out. One is how lonely this can feel. It doesn't matter if you're a man or a woman, young or old, whether this relationship is long-term or short-term, how you got together. The point is, right now, you may feel really up against it. Most people feel like they're making this transition completely and utterly alone. Even if that's not true, that's very often how it feels. Even if you have a support system around you, you can feel like you're the only one going through this. You don't know where to turn. You don't know what to ask. You don't know what the answers are that you're looking for. When you remove someone who's been your other half of your life, it leaves this chasm, especially if you're both responsible for kids that you're creating together. Everybody's in the middle of this messy time. You're not sure what to do with your kids. You're not sure how they're going to react. You're not sure how to handle this thing called a divorce. So that's why I decided to create this podcast. We're calling it Make Sense of the Mess. Each episode, we're going to take on a different question, some big conundrum that you face as a co-parent, some very important issues that you must handle in the early stages of a divorce. And we're going to break down those questions with the hope that you'll walk away with some better handholds. Specifically 4 C's: clarity, courage, context, and community to work through this very messy time. So here is how it's going to work. In each episode, we're going to take on some new topic, something that is timely for you, something that is really urgent and necessary for you to attend to, that you need some answers with. How are we going to do that? We're going to invite some real-life people who are going through what you're going through. We're also going to invite some experts in the field to discuss kind of the best things to do, say, not do, not say. And together, we're going to really plumb the depths of these issues so that you get a much better handle on what to do and how to do it. So this is not something you're going to go through alone. You're going to have us to take with you along the way. Buckle up and join us. So glad you found this show. Together, let's make sense of the mess. In this episode, we're going to turn our attention to something really important. That is, how to select the legal process and find an attorney, how to work with them effectively, and what to expect from each legal process. This might be the most important choice you make in your divorce, whom you select as your attorney and the process you use to follow. Broadly speaking, you can choose to litigate or to mediate. Those are the 2 broad ways of looking at this. Let's talk a bit about how to find an attorney. You're going to get recommendations from everybody under the sun. Please give yourself the opportunity to meet with at least 3 before you make a decision. Why 3? It's kind of like interviewing therapists. You need to have somebody that resonates with you, who will be able to give you very tough news that you will hear because of how they deliver it. If the person makes you uncomfortable, if they're too aggressive for you, then they may not be the attorney you want to work with. But you also don't want somebody who's going to be there to hold your hand, because that is not their job. Their job is to represent you legally. Being an attorney in a divorce is really hard. It requires very specific knowledge, and it requires them to think quick and be fast on their feet. That's what they have to do when you litigate. It's just something really important for them to do their job. So they need your support. How do you do that? Well, you get their support by being as honest as you possibly can be with them about what you need and why you need it, but also be very honest with them about everything they need to know that would help your case. So no secrets. Please don't hold back anything from your attorney. If there's an affair that you've had, if there's money that's hidden someplace, if there's a business deal that's about to go south, if there's property that you own that your spouse doesn't know about, make sure that your attorney knows all of these things. No secrets from your attorney. They can't represent you if they don't have the full truth. What you tell them is confidential, but the fact is they need to have all this information in order to represent you effectively. They can't do it with one hand effectively tied behind their back. So we're going to talk to a panel of attorneys who will discuss all of these different processes with you. We're going to talk about litigation, mediation, and collaborative divorce. And with this panel, we'll also discuss another form of being an attorney that you're not familiar with, which is a guardian ad litem or attorney for the child. That is, in effect, when you go to court and you're headed for trial in a child custody litigation. In many jurisdictions, your child gets an attorney appointed for them. But the role is different from state to state, and it's important to know what some of the distinctions are. With that in mind, let's continue. I want to introduce you now to two distinguished attorneys that I know well. The first is Alysia Baker, who has had a career as a litigator in matrimonial matters and is now pivoting and turning most of her attention to doing mediation. The other is Kathleen Bloom, who is also a litigator, who is turning her attention towards being the attorney representing children in litigation cases. My hope here is that you will benefit from their wisdom, their experience. We'll talk about different processes related to divorce and child custody matters. We'll talk about which process works best for you and the pitfalls and benefits of different processes. You'll find this informative. I'd like to introduce our guests for this segment. Alysia Baker is an attorney with offices in Montgomery, New York and Rhinebeck, New York. And Kathleen Bloom from the firm of Bloom & Bloom, family-owned firm in New Windsor, New York. Both have had extensive experience as litigators, and I invited them as guests because as part of their biographies is something a bit interesting. They both made a pivot of some sort in their careers to not just working as litigators, but in Ms. Baker's case and Alicia's case, working more as a mediator and using that as a frame of reference to how she resolves cases, while Kathleen has worked as an attorney for the children in litigation cases, which is a very different perspective. So I'd like to start the discussion with you, Alysia. Could you talk about some of the different processes that a parent might be engaged in? I mean, how do you choose how to do a divorce? How do you do that?
Well, there's three main processes. There's the traditional, which most people are familiar with, which is litigation, wherein both parties retain counsel and they file in court and they go to court over many sessions before a judge who will control the progress and the process and the speed of their case. And then there is something called collaborative, which is a little bit more of a nuance off of mediation. Not a lot of attorneys practice in collaborative, but it's where both parties hire attorneys who have been trained in collaborative and they have a written agreement that they will not go to court. And if they do go to court, they cannot use the attorneys that they've done work with in the collaborative process. And then finally, there's mediation, where the parties work together, usually with one, sometimes with two mediators, who is a neutral individual who will guide them through discussions, negotiations, and crafting a resolution on all matters, including custody, equitable distribution, division of their assets, in a way that they seem and they feel is appropriate for them. And how to choose the process really is how much controversy there is, whether or not you have extremely complex financials and wherein one party may not be disclosing all of their assets and there is a trust issue. But most cases, if the parties are properly guided, should be able to resolve their matters through mediation or some type of collaborative approach if they're given the right guidance.
Now, I'm wondering, if we talk about litigation, what are the kinds of expectations do parents generally have when they come into the process? And I want to hear from each of you about how you help set those expectations about how the litigation is going to go, what the process is. and the kinds of resistance you may run into with the parents from time to time. Alysia, you first.
I'm a very direct attorney. I like to set the expectations low, actually, so that people are really prepared for the worst case scenario rather than inflate their expectations so that it's realistic what the hurdles are that you will go through in court, how each individual judge may view your case. Because every judge, even though the law should be the same across the board, they have their own biases. And so, depending upon which judge you have assigned. And also the idea that when you go through court process, it's not a quick process. The courts are, particularly post-COVID, are overwhelmed. There are a lot of cases. They have a huge backlog. And it's not expeditious in terms of getting resolution. And if the parties can't come to a resolution, a stranger, this judge who does not know their family, and if they have children, doesn't know their children, is going to make a decision for them. And I think it's extremely important that they have realistic expectations.
I agree. I share in a lot of what Alysia just said. I am extraordinarily direct with my clients at the
Kathleen?
outset. I have a tendency, I tell them the worst case scenario. I tell them the best case scenario and all that's happened and what I've seen in between. Managing a client's expectations from the initial consultation is critical, absolutely critical. And also assessing their personality and, more importantly, assessing how they're portraying their ex or their soon to be ex, and the dynamic of their relationship is also very important in my practice when I'm representing the parents. So I can sort of gauge how my approach will be in how direct I need to be with this client or how gentle do I need to be with this client, their sensitivity levels, things like that. I pay very close attention to their emotional status at that time. And then I take that with me as I'm explaining. Some people need more explanation, legal explanation. Some people need less. Sometimes they want me to do everything and they want me to do more for them, that kind of thing. But yeah, it's a case by case basis. And Alysia has a lot more experience than I do, but I feel as though when you're practicing this and only this for even a shorter period or a longer period, you see it all, and I can relate to everything Alysia said.
I'm wondering how litigation affects litigants, the parents, through the process. What do you generally see as the changes that an individual parent is going to go through from where they started out as they move through the process and where they end? Because the process is cumbersome. It's long. It's much longer than anybody anticipates. And I think the point is well taken about COVID and post-COVID. It's just lengthened the process. So it's rough. I'm wondering if you could each speak to a little bit about that aspect of it and how you manage some of these changes emotionally. What do you see in your clients? How do you set the record straight? How do you continue to adjust expectations and help them move towards settlement?
I find that with litigation, parties start becoming adversaries. And if I can contrast that with mediation, mediation, as I was indicating before, what I try to do is more of an interest based. What can we do that can address both parties' needs? And in interest based, sometimes you ask one party to solve the other person's interest. So if it happens to be a husband and wife, you may say to the wife, how can we address what the husband needs? And vice versa. Whereas in litigation, it truly becomes a adversarial, and it's all about yourself and your own needs. And oftentimes what I try to do when it really becomes about one person's needs, if they have children together, is to refocus that onto the children. Because what ends up happening is people become very entrenched in a position. And it may not even be a large issue. It may not be about the house. It may become about, I don't know, pots and pans. I mean, I'm exaggerating, but it becomes very position based, and it becomes hard to move off of that. And it becomes much more of a tit for tat rather than a global viewpoint of how the entire case. So people start to focus on minutia, and it becomes a battle, if you will. Well, he won this or she won that, or if the same sex couples, he won whatever. And it's really not looking at the family dynamics as a whole. So I think that's how you start to see things progress as it goes on, unfortunately.
Kathleen, is that your experience as well?
Yes, absolutely. Alysia used the term minutia. I find myself recently using the term going down rabbit holes, telling my clients, you're going down a rabbit hole. Remember, we talked about what a rabbit hole is, and bringing them back to the big picture, bringing them back to the reality that is the courtroom and the judge that you have been assigned and the players involved, and then the law and how everybody is interpreting those things. There are so many parts that need to be navigated, and you're navigating them on their behalf as their attorney, but then you're having to explain what you're navigating to them, and they go down a rabbit hole of an issue, and you have to pull them out of it and then bring them back. Very easily, they can lose focus of the big picture.
Yeah. So it sounds as if the deeper you go into the process, the more that dynamic exists, the having to retrieve your client and reset expectations and reinforce them. Part of my experience in working with attorneys in litigation is I'm also interested in watching how the process transforms the attorneys in the case and sometimes the judge in the case. I mean, I'm fond of telling people when I do forensic evaluations or I'm doing therapy, judges are people too. They have bad days. Their calendar is full. You don't know who you're going to get when you go in and appear for a hearing that may last for 20 minutes. You may be doing something that sounds archaic and confusing to you. It's legalese. It's not plain spoken, and you don't speak for yourself. Your attorney speaks for you. Unless the judge asks you to speak, you're quiet. So it's a confusing and daunting process for people. And the lack of certainty in it, I think, elevates their sense of tension as things go along. Could you just speak a little bit to what happens, that adversarial piece, what happens with your colleagues on the other side when you're in litigation, a protracted litigation, and how judges experience cases that don't resolve? What do they think?
I can't speak necessarily to the judges and what they feel, but what I've seen from judges is exasperation. They get frustrated, they get annoyed, and oftentimes they can take it out on the party and or attorney who isn't bending or taking their advice. In terms of the adversarial process, people always ask me when they come in, one of the first questions or within the consult, how much and how long is this going to take and cost? And when I first started my practice, I would give estimates. And I realized it's completely unrealistic because the two things that are the most determinative is your spouse's personality and who they get as their lawyer. And who they get as their lawyer makes a huge difference in terms of how adversarial. Many lawyers, I think unconsciously, begin to emotionally align with their clients. And probably as a client, that feels reassuring, right? You're emotionally supported by your attorney, you both malign your spouse, and it feels good. But what it also does is it makes the attorney start to put their heels in as well. And they become so connected in the case that they lose sight as well as of the global picture. And it becomes an adversarial process with their colleague. And it becomes who's a better lawyer or who's going to quote unquote win this or get the upper hand instead of stepping back and saying what is best for this family and guiding their clients. So when attorneys promise the world to their client or become so emotionally connected and aligned with their client's position, it's not a positive thing for resolution. And I think it's very easy because many of us really, really like our clients and we would, become friends with them. But while you're representing them, it's very important to try and still be objective as to what is realistic and also what's equitable. If you have an attorney that goes in and says, I want to get 100% of everything, A, it's not equitable, it's not realistic. And it becomes extremely adversarial. And unfortunately, what ends up happening oftentimes, unless are multimillionaires, is that the end of the process is resolved not because the parties have agreed to the resolution, it's because they become exhausted and they just want it over. Or their legal bills and their financial distress is so extreme that they just end it. And those are not good results. I don't find those to be good results because nobody's happy because they just literally ended it because they're exhausted.
Kathleen, I'm sure you've had similar experiences. And I'm also wondering how you manage when you do have somebody on the other side, a colleague on the other side representing the other party, that is drowning everybody in motion practice. There's paper after paper being filed. There's all kinds of new allegations. There are things that are both inaccurate and distorted for the benefit of advancing this adversarial process and trying to win. And it's going no place, but yet you must respond. What could you tell a listener about what's going on when that's the circumstance? How do you soothe them? For clients that you have that are in the midst of this, what do you tell them about what the process has become?
I have a tendency to be not only direct, but very, very honest with my clients in how I view a situation like that. So, if what you just described, protracted litigation, unnecessary motion practice, I'm honest with them and I tell them exactly that. I think all of this is unnecessary. I think it's a waste. I think they're just trying to advance their position on the other side. And what I do is in my responses to the motions, try and point that out in my analysis and my oppositions. I try to send a message to the other side and to the court respectfully and diplomatically that this is unnecessary. Of course, you can try and raise as many arguments as you can to try and stop it, but it's hard because they can make them. They can make the motions, and it's very frustrating.
Would it be fair to say that both of you have experienced situations where you can't change this process other than informing your client about what's happening and making appeals to the judge in a case because you need to respond? If somebody files paperwork, files a motion, you need to respond in kind. Somebody sends a letter with an accusation about your client, you kind of need to respond. And that it seems like the process can get very weighty and off track. So now you're no longer talking about the financials really, and you're not really talking about the kids and their interests. And you're not talking about parenting plans. You're talking about you're in this pitched battle for who is going to win. As Alysia, you mentioned the minutia, and Kathleen, you referred to as going down the rabbit hole. That becomes the substance of the interactions, which is really unfortunate. Every matrimonial attorney I've ever known has had some experience like that. And I know it's frustrating to you, but I want to turn now to the kids in this because the kids seem to get lost in this process. They become an afterthought at some point, or the expectations of the parents themselves wind up getting inflated about their parental rights without a consideration of the fact that this person that they're in a pitched battle with is also the other parent. So I'm wondering if we could talk a little bit about the child's voice in court and litigation. And that's the kind of work you're doing more of, Kathleen. Could you talk a bit more about the attorney for the child and what that role is?
Sure. Being an attorney for the child has been probably the most rewarding part of my practice. And it's fairly difficult, more difficult than I thought it would be, because take two parents, which is what I'm dealing with mostly, who are in a high conflict divorce, usually, or family court setting over custody in that situation. The children are in the middle of that high conflict, and the amount of pressure and stress that they are feeling is equal, maybe more, than each of the parents. And the difference is that when I represent one of the parents, they come in here and tell me everything. And I can ask any questions I want to. I don't worry so much about if I'm offending them, or they don't take offense usually. It's a very open dialogue. Whereas I have a child that comes in here of this high conflict couple who are fighting in court, and they don't even know who I am or why they're talking to me, or they do know who I am and why they're talking to me because both of the parents have told them and put all kinds of things in their head. And a lot of times I have to peel back layers and really navigate talking to this little client of mine. And I have to oftentimes start out with, how's school? How's it going? Just to get them to talk to me, which is much different than a parent that I would represent. They come in, they sit down, and they get right to the point. With children, a lot of times they don't want to, they're scared to, they don't want to talk to me about it. I'm the last person they want to talk to about who they'd rather live with or what a schedule might look like.
So I think that kind of begs another question, which is how then do you accurately represent a child's needs,
Mm-hmm.
even sometimes as opposed to their stated wishes? In court, if a child has a particularly young child has a hard time expressing what they really feel.
Well, it depends on the situation. So, a very young child, I'm obligated to advocate zealously for my client's position, which I personally might not believe is in their best interests. It's not easy, and I'm not always the favorite when I have to go into court and do that. But that's my job, and that's what I have to do. I also am permitted when I'm with my client to take the time to explain to them what a best interest situation might look like for them. I can talk to them a lot about pros and cons and what their position is rather than just take it at face value and go into court. And I do that when I say peel back the layers. Sometimes it takes me 2 hours. And the position that my client, my young client came in with initially has changed. And they say, am I going to get in trouble? My mom's going to get mad at me. I think my dad's going to get mad at me. Don't say anything, okay? And then I have to be really careful when I go in there. I have to be really, really careful because I don't want any additional pressure being put on my client by either parent with the position that I'm going to state on the record. So I have to do it delicately because I might surprise one or both parents with what the child actually wants.
Alysia, I'm wondering if you could speak to how you prepare your clients when there is an attorney for the child that's appointed, kind of do's, don'ts, how they're supposed to comport themselves. What do you say to them about the pressure they may want to put on their kid?
I may take a different approach from some of my colleagues, even though I am a voracious litigator, and I am very competitive, you will. When it comes to the children and the attorneys for the children, or even a forensic evaluation, I really tell them to step back. I really strongly advocate they do not talk to the children. They do not even discuss with them anything about access, just to tell them that the attorney for the child is somebody who's going to represent them and it's all private and they can talk to them and tell them anything that they want. And I am really adamant about do not ask them after their appointment with their attorney what they discussed or anything. And the reason for that is to put the children first. And I also find if parents do that, it always backfires, because if you have a good attorney for the child or a good forensic, it's going to come out because the kids don't realize it. And they're going to say, well, mom told me this or dad told me this, or they come in and they say, I want visitation these days and that days. No 8-year-old, 9-year-old, 10-year-old is going to go and have that information. So when parents think that they're being
Slick.
coy and
Coy is
slick,
nice. Slick is what
slick,
you're looking.
it always backfires. It always backfires, and it's just the wrong thing.
Right.
But I don't know if all of my colleagues give the same advice.
They don't. And I can tell
They
you,
don't.
as the forensic evaluator, one of my common questions to young kids is, after I establish who I am and why I'm doing this evaluation and evaluating their family and why they're there, I'll ask them, is there something you were supposed to tell me today? So kids from as young as 4 to 7, 8 years old will usually perk right up and say, yes. And then they'll tell me the litany of things that one parent told them to tell me, sometimes in the waiting room or in the steps on the way up to my office. And I leave the door ajar so I could hear. So I hear the orders given, and then the kid very dutifully tells me. And then when they're done, I said, is there anything else you need to tell me? And they said, and they think, and they have another thing to tell me that they recalled. Oh, yeah. And mommy told me to tell you. And, then they blurt that out. And then I say to them, do you feel better now that you've said everything you were supposed to say? Yes. Oh, good. Could we talk about some other things? Let's talk about school. Let's talk about your baby brother who really annoys you. Let's talk about your best friend in school. Let's talk about, Mrs. Hanrahan, your first grade teacher. And you see the kids' affect change quite a bit. But this notion about them coming in prepped, I would have to say, and the two of you would never do that, but so many of your colleagues do even rehearse with their clients what to tell their children. Make sure your kid tells Dr. Mednick X. And you're right. You're absolutely right. It always comes out in the forensic. It comes out in the discussions with the attorney for the child. It's not a good look. And you have to reclaim the child's status as a child. That's all a kid wants, is peace. That's all they're looking for. So it's an interesting kind of process, and everybody thinks they can game the system. You can't do that with kids, can you? So it becomes an interesting process to manage. When you run into a client who is not listening to your counsel, what's the best course of action? How do you address that?
I've had 2 recently. I'm more direct than I normally am in situations like that. I tell them that please do not make my job harder unnecessarily. And what you're doing is making it harder. And one of them is just hair trigger needs to write back when they're being baited under all circumstances. And we talk ad nauseum about it. Please don't do this. This is why. Please don't do this. This is why. And then eventually I say, listen, I can't save you. I can't. And you're not taking my advice. So maybe you should move on. Or they, I know. I'm sorry. Well, I got to get myself under control. But I put it in writing to them, what's happening in an email, and that I need the conduct to stop to make my representation. I said to somebody recently, I can't do my best for you if you don't do your best for me. That's what I said to them. And that's it, and sometimes they listen and sometimes they don't.
Sometimes they don't. And I know from experience, both of you are very good about utilizing mental health professionals and making referrals to people when you have a client who is difficult, and you encourage them to get some of the help and relieve some of their tension. Alysia, how about you? You have somebody who is, or have you had a couple of people in mind that were somewhat difficult to work with and made your job difficult?
Yes. The process gets it, right? You're getting people and you have to appreciate you are meeting people at one of the lows of their life.
Yes.
And I think you always have to keep in mind that the people we're dealing with are in pain, and you have to have empathy for them. And it really depends on how they're not following my advice. I've had people who have given up the farm, so to speak, not following my advice because they want it over with. And I have to respect that. With that, I have them sign something that says, although I know that I'm entitled to A, B, and C. And I think as an attorney, you have to respect people's decisions because it is their life. It is their family.
So it sounds like things always work better if you have a client who can be coached, a client that is responsive, a client that has their children's best interests in mind and is more invested in that than in conflict. Thanks for joining us. It'd be really cool if you could spread the word. You know someone who could use this? Well, don't forget to subscribe and leave a review, but also share more with somebody about our mission to help co-parents feel less alone. Please share this podcast freely. That's my shameless plug. For more tips and tools about how to navigate this time, please go to makesenseofthemess.com.